Judge Cannone issued her opinion and order on Karen Reed's motion to dismiss yesterday. I was able to go through that, and now I'd like to share with you some of my thoughts on her analysis in that opinion. Now, if you've been following the channel, then you know that when this motion to dismiss was filed and we went through it and we saw the oral argument, I thought that the most appropriate course of action would be to schedule an evidentiary hearing. I did not say that the motion to dismiss should be granted outright. I think that we required an evidentiary hearing in order to really get to the bottom of some of the allegations that were made in the defense's motion to dismiss. So I thought that that was the most appropriate action. After all, the whole point of an evidentiary hearing is that we don't have all of the evidence in front of us. We have some evidence which can suggest some prosecutorial misconduct, but in order to really get to the bottom of it, that is why you have an evidentiary hearing. So that was my opinion, as you know, and Judge Cannone disagreed with me. She said that she is denying this motion, but she is also denying the alternative request for an evidentiary hearing. So let's go through some of her opinions, some of her analysis, and I'm going to be giving you my thoughts on some of her analysis. So here we go. Let's pull it up. And of course, we're not going to go through the entire opinion. You probably may have read it already or seen other attorneys read the entire thing, but we just point out some different parts of this. Now, the most compelling argument here is the argument about the videos, about the surveillance videos. And really, that was what Alan Jackson concentrated on during oral argument. He didn't really mention so much about the Jennifer McCabe stuff. And I thought he could have mentioned one part of the Jennifer McCabe stuff, and that is that Lieutenant Tully decided not to write the report for 20 days and then turned it over to the defense late. So I think that could have also bolstered his argument of prosecutorial misconduct. But in terms of the whole Jennifer McCabe situation outside of that is not the strongest argument. Alan Jackson realized that, and that's why he didn't really focus so much of his attention on that part of his argument during the oral argument. So we're going to really be concentrating on the part about the videos. So let's go. Two parallel legal principles govern the resolution of cases involving prosecutorial misconduct where dismissal is contemplated. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should not be allowed absent a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. As we already know, as we've spoken about on this channel, generally speaking, when you have a Brady violation, when you have a discovery violation, the remedy is a mistrial. The remedy is another trial. But here, the argument here is that it's also prosecutorial misconduct. And is it that because of the prosecutorial misconduct, therefore she has been harmed in a way that cannot be rectified by a new trial? So that's really what we have to focus on. First, so now these are the two principles. First, where the prosecutor fails to disclose evidence, the defendant is entitled to receive. Oh, I just read this. I'm sorry. Let's move on. Alternatively, in rare circumstances, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights, may give rise to presumptive prejudice, and the drastic remedy of dismissal of charges may become an appropriate remedy. And again, this is all from case law. The latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. So therefore, one of the things that you have to focus on if you're analyzing this is the repetition of this misconduct. Is this just a one-off prosecutorial misconduct allegation, or is this something that we're seeing a pattern of, or seeing a repetition of? So if you stop right there and talk about the Sally Port videos and these surveillance videos that keep coming in piecemeals, well, what's going on with that? This is repetition. Why didn't they get all the videos at one time? Or if not at one time, at a second time, but not a second time, then a third time, then a fourth time. So we are finding some sort of repetition here. So right away, that would go in favor of Karen Reed. Okay, now let's move on. Talking about Rule 14. The rule in effect at the time of the discovery issues here provides that the prosecution shall automatically disclose to the defense certain evidence relevant to the case and in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction and control, or persons who have participated in investigating or evaluating the case. Now, this is an important part, that second part, because part of Alan Jackson's argument was that, look, the prosecutors could have done nothing wrong in this case. It's possible that the prosecutors didn't do anything wrong. They're not the ones who are doing the things wrong here. If Trooper Proctor, or ex-Trooper Proctor, or former Trooper Proctor, however you want to call him, if he, Michael Proctor perhaps, but if he was the one who was the one that committed this misconduct, well, then that attaches to the prosecution because that, after all, that is a person who has participated in investigating or evaluating the case. So this is part of the argument that Alan Jackson was making, that, look, Hank Brennan can be completely fine. Could be he did nothing wrong. Could be Adam Lally did nothing wrong. But if Proctor is hiding evidence or manipulating evidence or changing evidence, well, then that also, unfortunately, is stuck to the prosecution, stuck to the Commonwealth, and therefore these allegations of prosecutorial misconduct can go forward. Okay, so that's an important part. Let's continue. According to the Commonwealth, surveillance footage from these cameras is automatically overwritten on a regular basis. Footage from the night in question was not lost, however. So let's stop for a minute before we get into Sergeant DGM Petro. According to the Commonwealth, well, how do we know that? Here's the question that I want you to ask as you're reading through this opinion. How do we know that? And why wouldn't an evidentiary hearing make sure that we know that in a way that is through sworn testimony, documents, proofs? So this is just, according to the Commonwealth. Well, that's exactly the point. The point here is that we need an evidentiary hearing, so we're not just assuming that what people are telling us is accurate. We want to know for sure because we brought up significant issues and we have to get to the bottom of it. So we're going to find this pattern in this opinion. According to the Commonwealth, surveillance footage from these cameras is automatically overwritten. How do you know that? Because that's what Hank Brennan said? Okay, well, let's get to the bottom of that. Is that actually true or not? Let's get the people on the stand. Let's see if that's actually true. And then again, footage from the night in question was not lost, however, because CPD Sergeant D.J. Petro followed his customary practice of downloading the recording to a hard drive in 6-hour segments. Really? How do we know that? How do we know that that's his customary practice? How do we know that he was actually following the policies and procedures of the Canton Police Department? What are the policies and procedures of the Canton Police Department when it comes to keep this footage? What are they? And who is supposed to be following them? And is it actually Sergeant DGM Petro's job to do that? Or was he doing it on his own? These are questions that we don't have the answer to and are not going to have the answer to. That's exactly why an evidentiary hearing would be helpful. Okay, but again, this is what Judge Cannone is adopting as true. Let's continue. The lead investigator in the matter, Massachusetts State Police Trooper, or ex-trooper, former trooper, Michael Proctor, took possession of requested CPT video of the Sally Port on February 2022, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. So let's stop again. Instead, for reasons unclear on the record. Well, why don't we make them clear on the record? Isn't that a good idea? We don't have clarity on this issue right now, right? So wouldn't an evidentiary hearing help to clarify if that's what he actually did? So he kept the material in his case file. I mean, how do we know that? We just don't know. All right, continuing. Several months later, in June 2023, Proctor asked CPD whether it had in its possession any exterior Sallyport video showing the defendant's vehicle on the flatbed of the tow truck on January 29th, 2022. And again, footnote 3, it is unclear to the court why Trooper Proctor requested the footage at this time. Well, that's a good question. Wouldn't you want to clarify that? And an easy way to clarify that is by having an evidentiary hearing. Let's get ex-trooper Michael Proctor on the stand and let's ask him some questions about this. Why did you wait? What's going on in June 2023 when you all of a sudden decided to request some additional Sallyport video? No, it's unclear. So let's just leave it that way. According to Judge Cannone, let's just leave it unclear. Continuing. Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutors. Well, why don't we get to the bottom of that? Here we go again. Reasons unexplained. Well, let's get an explanation. Instead, he placed it in his case file. Says who? Says who? How do we know that he placed it in his case file? How do we know that that's exactly what he did? And that's the extent of what he did. And that would just sat there for months. How do we know that? How do we know any of this? Continuing. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue and dispute in the case, cannot be discerned. Well, that's true. That's how the recording looks now. But how do we know that that's how the recording always looked? How do we know any of that? We don't. Which is why an evidentiary hearing would be helpful. All right, let's continue. 3 months later, on April 4th, 2024, Adam Lally received, the federal grand jury testimony. Lally immediately turned over the Sallyport front wall camera footage to the defense, along with footage from the CPD main driveway showing this SUV on the flatbed. 4. It is, again, footnote 4. It is unclear to the court where the CPD main driveway footage came from. Well, that's a good question. Isn't that an important question to get the answer to before trial? Wouldn't an evidentiary hearing help for that unclarity, to clarify that? All right, continuing. When defense counsel reviewed the Sallyport front wall camera footage, they saw that 42 minutes of footage was missing. The defense raised the issue to the court at a hearing on April 12, 2024, days before the trial was set to begin, arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated. Do we have any clarity about that? Can we get some clarity about that? And if that's the case, then how come it didn't catch or record when Karen Reed's car was driven into the Sallyport or brought it into the Sallyport? So all this are just questions that we don't have answers to. But the Commonwealth explained that, so let's just assume that whatever the Commonwealth, whoever she's referring to as the Commonwealth here, probably the attorneys, Adam Lally, perhaps, if that's the explanation, so that's what we should take just completely 100% as true, which, again, is exactly the problem here. Now, State Police Sergeant Buchanek testified on June 5th and 6th, 2024. And that's when they had the inverted video, right? That's when the inverted video came out. Okay, on cross-examination, defense counsel pointed that out. Okay, now, what happened on June 5th and 6th, 2024? That's when this inverted video got introduced and was brought out that it actually is inverted. Well, the CPD began a review of other video surveillance footage in an attempt to explain the inverted image and to respond to allegations that it had deliberately manipulated the recording. How do we know that they began a review? Who told us that? Hank Brennan? Adam Lally? Who told us that? How do we know that? What type of review did they do? What was the extent of the review? Who was involved in that review? We don't know. As part of this process, CPD Chief Rafferty reviewed surveillance footage from cameras in the hallways and the parking lot of the CPD in the early morning hours of January 29, 2022, prior to O'Keefe being discovered in the snow. How do we know that? How do we know that? Because Hank Brennan told us that? But that's part of the issue here, is that how do we know any of this was done and who did it and who did what and where was the chain of custody and all that stuff? The rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m. holding a phone near his face. And you just love the way that she says this, holding a phone near his face. We're going to get a little bit more into that in a second. In September 2024, Special Prosecutor Brennan joined the prosecution team. On October 10th, 2024, he provided the rear lot cruiser footage along with other surveillance videos. So stop for a second. I thought we just said that on June 5th and 6th, 2024, that is when this issue of the inverted video came up. And that's when Chief Rafferty decided she's got to review all this surveillance videos. And then what happened to all those surveillance videos? What happened to the rear lot cruiser side camera that recorded Brian Higgins holding a phone near his face? That wasn't turned over, was it? So what happened there? Why wasn't it turned over? What happened to that video between June 5th and 6th of 2024 and October 10th of 2024? Do we know the answer to that? No, of course the answer is no. We don't know what happened to that. Continuing. As noted above, the footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage, but the quality of the recording is, as noted, poor. So again, we're seeing different quality of the videos. That's also a question. How come some videos are clear and some videos are not clear? Why is that? Can we get an answer to that? That's something that's unclear. Continuing. First, so here the Judge Cannone continues with her analysis. First, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. So remember, there were some orders that were entered into at the different court levels. And here, Judge Cannone is going to show very clearly that really there was never a formal request to produce specifically the CPD surveillance video. The February 2nd, 2022 preservation order required the Commonwealth to preserve all physical evidence. Now, she brings some very interesting case law. Massachusetts case law reflects a clear distinction between physical evidence and video surveillance footage. So she quotes a whole bunch of cases here which show that there's a difference between physical evidence and video surveillance footage. So that's the argument there, that even if you would like to argue that the preservation order required them to preserve physical evidence, well, surveillance video surveillance footage would not go into specifically that request for physical evidence. So she brings a number of cases for that proposition. The October 5th, 2022 order on the motion to compel discovery also did not require the Commonwealth to produce any CPD surveillance video to the defense. So now, then we have the October 5th, 2022 order on the motion to compel. This was in front of Judge Cannone. And also that did not require the production of any CPD surveillance video to the defense. Okay, the order required that they turn over all crime scene photographs and or videos. And yeah, we know that Morrissey called the CPD the crime scene, but okay, we're going to kind of ignore that for now. Now, this is not the end of the inquiry, however. And that's true, because the absence of a court order requiring production of the CPD surveillance does not foreclose the possibility that production may still have been required under Brady and or Rule 14. So like I've been saying from the beginning, it doesn't really matter so much whether there is an actual formal request or formal preservation order, because if there is exculpatory material, then the prosecutor and anybody who works for the prosecutor has a duty to produce it and to save it. So continuing on here. In addition, while the current Rule 14 makes clear that the Commonwealth is required to disclose to the defense as investigative materials video and audio recording, so that's in the new Rule 14, in the possession, custody, or control of any member of the prosecuting team, the Rule 14 in effect at the relevant time had no such requirement. Nor did Rule 14 in effect at the time clearly state the prosecutor's duty to inquire whether such evidence exists. So here's the question about duty to inquire. What's the prosecutor's duty to inquire? Now, there's one place where you can look, which is Rule 14, and there's also the case law, which would include, obviously, the duty to inquire of any exculpatory evidence. Again, because the defendant made no specific request for the Commonwealth to produce such evidence until after the first trial, it is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. So here, what she's saying is that when do we expect the Commonwealth to understand that, wait a minute, we're making a defense here that this was all planted and there's one big conspiracy going on, and that really her taillight was completely fine going into the satellite port? When would the Commonwealth reasonably know that that was her defense? And what she's saying here is what? It's not clear on the record. Well, that's a good point. It's not clear on the record. So what should we do? What should we do if it's not clear on the record to clear these things up? When exactly did the Commonwealth know about the defendant's position here and their defense here, that they're going to be arguing that there was some manipulating or hiding of evidence by the Canton Police Department or by Trooper Michael Proctor? When did they know that? When did they know about that defense? That would be a good question to ask in an evidentiary hearing, right? That's a good question to get to the bottom of in an evidentiary hearing. But instead, just leaving this, well, we don't know. We don't know. Until the Commonwealth knew, for example, that the defense theory included that law enforcement tampered with the taillight while it was at the Sally Port, or that Higgins was a proposed third-party culprit, it had no reason to inquire as to whether any relevant video footage existed. Agreed. 100% agreed. Until the Commonwealth knew, then you can argue that the Commonwealth had no duty, the prosecutor had no duty to inquire. When did that change? That's what I want to know. When did they know? Do we know the answer to that question? No. So why are we happy just living here in ignorance? Don't you think that an evidentiary hearing would clear that up? Of course it would. But instead, we're just going to be ignorant and not have an evidentiary hearing. Now, look at 6 and 7 here. This is the footnote 6 and 7. You know how much I love footnotes. Let's take a look at footnotes 6 and 7. Defendant also argues that the rear lot cruiser side camera footage should have been turned over because it was exculpatory impeachment evidence that the defense could have used to show Higgins perjured himself before a federal grand jury when he testified that he did not call anyone on the night in question. Now, I think one point should be also made is that that wasn't just his testimony to the federal grand jury. That was also his testimony in the trial. So it's not just to use that evidence against Higgins to show that he perjured himself in a federal grand jury proceeding. It's also to show impeachment of his actual testimony during trial. Defendant's memorandum at 20. That argument fails for several reasons. First, it is not at all clear how, within the bounds of admissible evidence, the defendant can introduce evidence of this alleged perjury at her criminal trial. Well, like we just said, it's not just to show impeachment of what he testified in the federal grand jury. It's also to show impeachment in what he testified in trial. Everyone would agree that that's admissible. Second, even a cursory review of Higgins' grand jury testimony reveals that he said that blank, blank, blank. Third, the video at issue, a 4-second silent clip showing Higgins walking across the parking lot holding a phone near his face does not clearly show, as the defendant represents, the witness speaking to some unidentified individuals on the phone. Right? For all you see is that he's holding a phone to his face. How do you know that he's talking to anybody? Because very normal for people to just take a phone and hold it to their face. It's very normal when you're not talking to anybody. Where else would you put your phone? Do you have any other place where you'd put your phone? Of course not. Right? You just leave it by your face until someone calls. Like, hey, someone's calling me. Oh, great. My phone is right here anyway. That's a great coincidence that the phone was just here anyway when somebody called me. So, it's just pretty interesting stuff here. The clip does not reveal how Higgins is utilizing the device, and it in no way establishes that he perjured himself before a federal grand jury. All right. Okay. So, and then again, with respect to the main driveway side exterior Sallyport camera, even if Proctor should have turned it over to Lally prior to trial, the quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to the right taillight. Okay, fine. That is how it looks now. How do we know that that's how it looked before? How do we know that anybody tampered with it? Don't you think an evidentiary hearing would be helpful to determine that fact? No, not according to Judge Cannone. Let's move on. Nor has the defendant demonstrated that the metadata, talking about getting the metadata, would have been exculpatory evidence. She offers no evidentiary support for her argument that the metadata would confirm her theory that members of the CPD or state police doctored the footage to prevent jurors from seeing the condition of the defendant's taillight before it was within the custody of law enforcement and from seeing Proctor damage the taillight. So, she offers no evidentiary support for her argument that the metadata would confirm her theory, right? Well, that's why you have an evidentiary hearing. We have enough evidence to show that there's something weird going on with these videos. That's why you need to have an evidentiary hearing to find out what's going on with the metadata. And now the metadata can perhaps shed some light onto why some of these videos are very grainy. That's the whole point. So you're right. Right now, we don't have all the evidence. You're right. That's why we have an evidentiary hearing. Continuing. A defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility. Let's think about that. So this is a quote from a case. If you want to seek relief from the loss or destruction of potentially exculpatory evidence, then you have the burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his cause. So, do we have a reasonable possibility that the fact that no videos exist that show clearly her taillight, and there's a lot of videos out there, and some videos are better in quality and some are worse in quality? Is that not any sort of reasonable possibility based on the evidence that we have, those videos already that we have in evidence? Is this just fertile imagination? This is just completely nuts? I'm not so sure about that. So that is really what Judge Cannone finds about the Sallyport videos. So therefore, she finds that, lastly, as to this claim, to the extent that the defendant claims to have rights based upon the Commonwealth's handling of metadata, she will have the opportunity to seek redress in the context of the retrial. Well, not so sure about that, because if the metadata is lost and there's no clear chain of custody here, well, yes, we can bring up those arguments there, but we can't show videos that don't exist. We can't show videos that were manipulated or that were changed if we don't get the opportunity to find that stuff out. So that is exactly why you would have an evidentiary hearing. But again, Judge Cannone does not feel that it's necessary to have an evidentiary hearing. So then she goes through some Jennifer McCabe statements, and the only thing I think which was interesting here, which could have been helped bolster the Alan Jackson's argument, is that Tully wrote a brief report on the meeting, but it was not produced to the defense until May 29th, 2024. And she met with them a lot earlier than that. I think it was May 4th or something. So I may get that first date wrong, but it was like 20 days later. So anyway, that is this opinion. She goes through the Jennifer McCabe. She goes through the jury, the juror that was being dismissed, who apparently now is actually joining the defense team because she was a lawyer. So that's interesting stuff over there. But this is my take on this opinion. I think that first part, which is the most significant part of this, the motion to dismiss about all these Sallyport videos and why it would have been helpful to have an evidentiary hearing. And even Judge Cannone acknowledges so many times in that brief that there's things that are unclear on the record. So, I mean, that's exactly why you have an evidentiary hearing. I mean, I've been saying it the entire video, but that's it. That's why you have an evidentiary hearing. So, but that's her opinion and that's her order. So it's just going to go into the pocket of the appellate attorney if Karen Reed gets convicted in this case. So that's going to be it in terms of Judge Cannone's opinion. Again, we're going to be keep on following everything else going on with Karen Reed docket, see if any additional filings will be happening, and we'll be to follow the case. So if that's going to be it for now, if you haven't, please subscribe, like, and we will see you next time.